It's funny because some of the folks that I work with say, "Hey, you could go a little bit more in depth," and then my buddies say, "Hey, you're a little too far down." So as you
Okay.
might expect, that may be that tells me I'm hitting the right
Yeah.
somewhere right in the middle, right?
Okay, great.
Okay.
Let's go.
You're listening to Making Data Simple, where we make the world of data effortless, relevant, and yes, even fun.
Podcast listeners, we're back at the podcast, Making Data Simple. It's a good break from my regular scheduled activities. My guest today is Robert Plotkin. He's the author of The Genie in the Machine, How Computer Automated Inventing is Revolutionizing Law and Business. Robert is an early thought leader on the future of AI. He continues to ask and address questions like, what skills do I need to work with AI in the future? And how can AI impact invention and art? Look, Robert, I do my research and looks like you're a founding partner at Blueshift IP. We'll talk about that. You've been a lecturer at Boston University. As I go even further back, it looks like you're an MIT grad, computer science and engineering, but then you got that law degree at Boston University, which is going to make this extremely interesting. And I've already got a ton of questions lined up for you. Welcome to the show. I appreciate you being here.
Yeah, thanks, Al. Thanks so much for having me. I'm really looking forward to it. Yeah, as you said, I have a combination of a background in computer science and law. I have been a patent attorney specializing in obtaining patents for innovative software, including AI, for over 25 years. I represent companies at all stages from, the proverbial garage all the way up to multinational corporations and everything in between. And my focus is on obtaining patents to protect companies against their competitors, and at the smaller stages to help them raise money, help them get acquired, go public, and also to generate licensing revenue. I've had a long fascination with AI, particularly how it intersects with the patent system, ways in which AI is being used to automate the inventive process and the impacts of that on patenting. The big question that it raises is, can an AI invented invention be patented? And that was the primary focus of that book you mentioned, The Genie in the Machine, which I published back in 2009. Didn't get a whole lot of attention back then because AI was not as prominent as it is now. People didn't really see the real world implications of it. But of course, in the last year, since the new dawn when a ChatGPT was announced, everyone is interested in this. What's the impact of AI on innovation and on things like the patent and copyright system? So I'd love to talk to you about any of that, and including, as you said, for both inventors, professionals of all kinds, artists, what are the skills we need to take maximum advantage of AI to become more productive and effective and efficient at what we do?
Well, there's so many different places we could go with it. I didn't realize that book was 2009. You must have had the foresight to really get in front of all this. Pretty amazing. Is that because of the patent angle and you just could see this coming or what?
Yeah, I think, as a patent attorney, I have the opportunity to see new technologies often many, many years before they're hitting the commercial market. And I am really deep in the weeds with inventors, seeing how they invent things. And so I was starting to see how people were using AI. Interestingly enough, back then, it was primarily evolutionary algorithms, genetic algorithms, not neural networks, which are the dominant form today. But I was already starting to see people rapidly accelerating the inventive process using AI to invent things much more quickly, easily, inexpensively than ever before. And that was raising this question: can you obtain a patent on something that was invented using significant assistance from AI? And if so, how should the legal rules of the patent system apply to such inventions? So yeah, I started actually writing about that academically back around 2002. So it's really been exciting and
Wow.
validating to see all of this come to the fore in the last couple of years.
I see that you got many white papers out there, but that begs the question. I'm going to ask you all those questions. But before I do, So are you a techie? What's your brand? Are you a techie or are you a lawyer? If you have to fall over on one side of the fence, which side are you going to fall in on?
Well, as a patent lawyer, I get to wear both hats. It's one reason I became a patent lawyer and have stayed as a patent lawyer. There was a joke I remember being told by a partner when I was very junior, just starting my career. I won't tell you the whole thing, but I'll lead up to the punchline, which is basically a patent lawyer is often someone who failed at being an engineer and who failed at being a lawyer, so they became a patent lawyer. I like to think of it as I take the best of my skills, from both of those backgrounds and put them together. It means I can understand the language of my clients, of inventors and business owners and high tech executives. I can speak their technological language, and I can apply legal strategy and tactics to the technology because I understand how the technology works and I understand how the law works. So I marry both of those things together when I work with clients.
Could you be a patent attorney without an engineering degree or an engineering background?
You actually have to have at least a 4-year degree in an appropriate kind of field. The patent office has a list of these degrees, and you have to pass a separate bar exam called the patent bar, which enables you to get admitted to practice before the patent office. So you do need to have a science or engineering degree. There was a long time when it was hard to get admitted with only a computer science degree because the patent office didn't consider that to be technical enough. In fact, when I was admitted, is back in the late 90s, my degree from MIT qualified because it had enough of a electrical engineering component to it. But that just tells you that the law and the patent office practice often lags behind, where industry is. But
Imagine
yeah,
that.
you have to have a science or engineering background to be a patent.
All right, I got so many questions I want to ask you, but here's where I have to start. First of all, I've got 3 daughters. None of them followed the tech field like me, but they're all in healthcare. I'm extremely proud. And one is in the last year of law school. And she happened to call me earlier today before we were doing this interview. I said, "Hey, I've got a patent attorney on today." And she said, "Oh, wow." I said, "What questions do you want?" And she offered, before I could even say that, she jumped out. She had 2 questions for you. So I want to start with that. And then I'll come back in to basics and then ask a ton of different questions on top of that. First question is pretty simple. How did you get into this field?
It was really what I was just talking about, that I had always been obsessed with computer science. I started out as a programmer. I studied computer science at MIT. I was originally planning to become a software developer, but I also had other interests. I was really interested in philosophy, political science, writing, arguing, debating. I really liked all of those things. I started to find as I got towards the end in college that I didn't want to be that much in the weeds of, we used to call it programming. It seems like everyone calls it coding now, but I wanted to still be in the technology world, and going into law seemed like a good way to marry all of those skills together. And so that's what brought me there. So I would say to anyone else like your daughter, maybe who really likes science or engineering or technology, but maybe doesn't want to be doing the daily work of that all the time, but wants to be connected to it in some way. And particularly if you enjoy, again, that writing, arguing, strategizing about new inventions and technologies, then patent law can be a good field for you to get into.
Sounds great. By the way, she knows how to argue. She's been arguing since she came out of the womb. I always told her to go into law school, and first, I think it's just against her dad, right? No, no, no. And then finally she grew up and said, "Yeah, that's probably where I need to be." But having said that, so when you in high school, were you doing more techie things
Oh
like
yeah.
coding, or were you debating? Or are you doing both? Were you in like debate or anything? Or
No, I wasn't in debate, but I always enjoyed writing. I always enjoyed, as I said, philosophy, which involves thinking through ideas and understanding both sides of them, really all sides of them. And I was really particularly interested in creative writing, which helped a lot in writing the book and some of the other things I'm writing now. In fact, I remember when I was thinking of going to college, I was deciding between going into the technical direction, which was computer science for me, or into writing. And I remember I and my parents at the time thinking very pragmatically, If I go into computer science, I can always do writing on the side. It's a lot harder to go the other direction from an economic point of view. So if you go into writing, it's going to be harder to do programming on the side. So I went in that pragmatic direction, and it was a really good decision looking back on it. And of course, the whole computer industry has just mushroomed by so many orders of magnitude since then. I don't regret it. I mean, I remember though there were people early on, including a partner when I started at a law firm, probably 96, 97, when I was focused on software patents. And he said to me, Robert, don't pigeonhole yourself. You never know what's going to happen really with the whole software industry or software patents, whether they're going to be around anymore.
Wow.
In a while.
Yeah.
And of course, looking back, that seems really short-sighted. It has paid off for me because everything has become software. It looks like maybe soon everything will incorporate AI as well.
Your manager there wasn't named Charles Duell, was he?
No. And if you asked me who it was, I wouldn't tell you now anyway.
But you know who Charles Duell is, right?
No.
He's the gentleman that had the patent office in 1889 and is been regarded as saying, everything that has been invented has already been invented.
Yeah.
Although if you research it, I think that's a falsehood. I don't think he really said that. In fact, in 1902, he said something completely contrary to that. He supposedly said that in 1889, but in 1902, he also said, look, basically something along the lines of, I wish I was just being born in this new century because I'd like to see or have my life all over again so I can see the wonders that are on the threshold of being invented now. So I think he gets a bad rap for that. But anyway, coming back, so the second question she wanted me to ask you is the one that I figured would be the first question, which is, what's the coolest invention that you've helped patent?
Oh, there really is no single coolest invention that I've patented, but I've had I think the things I enjoy working on the most are the ones that have real positive impact on people. Inventions that are related to healthcare, for example. I've done a lot of patenting of natural language processing related inventions in healthcare. Early on, some of those did things like just help prevent transcription errors for prescriptions. And doctors, we can laugh at it, have notoriously bad handwriting. But on the serious side, that means often, there are mistranscriptions of what's been written down. People get prescribed the wrong medication, and that has really serious consequences. Take that to dictation, and you have the same problem. So just reducing prescription errors is a really significant benefit. But I've worked on all kinds of, I call health tech related technologies, and there's so much room for continued innovation there. And that's something I always just enjoy working on because I know that it provides a benefit to humanity. I would say on just the pure cool factor, I've done a lot of patenting related to quantum computing software. And, just the complexity of that technology and what it promises to be able to do if quantum computers can reach a certain scale, which is the hope that they will reach, it could open up an entire new world of innovation. So I've felt very privileged to be able to work on patents for that type of technology.
Terrific. All those technologies I'm involved with too. I mean, look, an hour isn't going to be enough to get all of this out. I got to ask you one more though, selfishly, for my daughter. She, I think, is going to actually go into family law because she wants to be a judge. I mean, she's got this plan. Her dream is to become a judge. Well, hopefully she'll get there someday. But if you're a law student, what advice would you give a law student today, just overall?
I mean, there's so many. I'll give one that's related more to the topic of today and one that's general. I'll give the general one first, which is get to know some lawyers. And if you can, shadow a lawyer for a day or two, get to see what it's really like to do the work of a lawyer before you may even apply to law school or go to law school. Because I found I had a lot of misconceptions about what being a lawyer were like, because where did I get those from? TV, books, movies, popular ideas about what being a lawyer was like. And those are not only inaccurate, at least for 99% of lawyers, they give a false impression about what it's like to really be a lawyer. So I'll give one example. When most people think of being a lawyer, they think of a litigator, someone who goes into court filing and prosecuting lawsuits. Most lawyers don't do that. I don't do that. I'm never in court. Lawyers who write contracts often don't go into court. Transactional lawyers, tax lawyers, trust and estate lawyers maybe spend a little bit of time in court, but even lawyers who handle lawsuits, the vast majority of lawsuits don't make their way into court. So your daughter or anyone else who's thinking of going into law, if you're doing that because of the allure of the courtroom, you may find yourself being disillusioned when you see what law is really like. Now, on the other hand, um, you know, the work that I do is working directly with innovators, innovative founders of companies, managers of companies, engineers, inventors at companies, understanding what their inventions are, understanding what their business goals, business models are, and working with them to develop an intellectual property strategy that's going to provide maximum protection and maximum support for those goals. That has almost nothing to do with lawsuits or the things you might think of, but I really enjoy it. And it enables me to bring all of the skills that I have and the things that I enjoy doing to bear. So the easiest way to figure out whether that will work for you as a lawyer in the future is meet some real lawyers, talk to them about what they actually do in their work. And if you can even get an internship or something else where you can experience it in the real world, that's the best advice I would give. The second thing I said, which I mentioned first, was understand that technology is rapidly changing how the practice of law works, just like it's changing every other field. So prepare yourself for that. And I think as a young person preparing to go into law school, you're probably in a really good position to take advantage of that. But just know that probably your professors in law school aren't going to know this. They're going to be teaching you things that were, the way to practice law 5, 10, 15 years ago. A lot of those basic skills are still extremely valuable, but you may need to do the work on your own to prepare yourself to practice law in the way that it's developing based on developments in technology.
I think that's fantastic advice. Thank you for that. I will say that the good news is my daughter has the I don't know what you call it, the gene or something of being able to get internships, and so she's had several. So and she's liked all of them within law. I knew that she picked the right field though when she loved the judge. She interned for a judge, and like I'd say, "What are you doing today?" And she'd say, "I'm going into the court session." And I said, "I thought you were off today." She goes, "Well, I am. But they called me and said, hey, you don't want to miss this one." And so she's going in there sitting, observing when she don't even have to. Yeah. That's when I knew, oh, all right, she's picked the right area. Then this is for her.
That's great.
So now we're 20 minutes in or close to it. And I'm going to back up just a bit to go forward. Now, before we began the podcast, you asked how technical my audience is. There's some that are very technical, extremely technical, architects as deep as you can get. And there's others that are not so technical. I try to keep it someplace in the middle, which probably ticks both of them off, which makes it perfect. Where I'm going with this is I want to jump into AI because I think it's the topic of the day, but and we'll kind of go a number of different places. But before I do, I got to start out very simple. And that is, what is a patent? IBM has led patents for many years. I think just this last year, we decided to back off a little bit, but something like 30 years. I don't know. I'll say that wrong, but a lot of years. So what is a patent? What rights does it really provide? What kind of inventions can be protected? And how long does a patent last?
Yeah. So a patent is a legal right that gives its owner the right to exclude or stop other people from making, using, and selling the patented invention. So Let's use the example of a mousetrap. Let's say you are clever enough to come up with a new kind of mousetrap, which is hard because there's been a lot of mousetraps invented for hundreds of years. You come up with a new mousetrap, and you submit a patent application to the patent office where you describe that mousetrap, how to make it and use it in words and in drawings. That document, the patent application, gets examined by a patent examiner who's an employee of the patent office, and the examiner has to apply a few different standards or tests to determine whether the mousetrap is new enough, useful, and whether it's what we call non-obvious, which is the trickiest thing, essentially whether that mousetrap goes beyond the state of the existing art in mousetraps in a way that goes further than what the typical mousetrap inventor would have thought of doing. It has to be ingenious in some way, but not necessarily by so much, just enough that it's beyond the norm. And if it does, the inventor or the inventor's company, if the company owns the rights, would be granted a patent, and then only that company would be allowed to make, use, and sell the mousetrap. Anyone else who wants to make, use, and sell that mousetrap would have to get the permission of the patent owner. That's basically what a patent is. And I won't go too far into it, but there are economic side effects of that, which is that very often patents, which are an asset, they're a kind of property that's owned, they have economic value because, let's say, another company wants to make that mousetrap. The owner can say, sure, I'll give you my permission for a fee, what we call a royalty or a licensing fee. And so you can generate rents essentially from patents. You can sell the patent. So it's an asset that you can use to generate economic value from as well. And in practice, for your listeners, that's the most common way in which patents are used. Very, very few patents are actually subject to a lawsuit. Although if you are the patent owner and someone else, let's say, starts selling that mousetrap without your permission, and you go to them and ask them to stop and they don't, you can sue them. And if you can prove that the mousetrap they're making falls within the scope of your patent, a court can award you damages and even an injunction. An injunction is a court order that tells the other company they have to stop manufacturing and selling that product. This does also apply to processes, which is what most software patents cover. Most software patents cover algorithms or methods carried out by software. Traditionally, those kinds of methods were industrial methods, like for manufacturing products, but you can get process patents on all kinds of things. So how long does a patent last? Essentially 20 years from the date on which you filed the patent application. Usually takes a few years to get the patent granted after you filed it. I don't remember whether I got all of your questions.
I think you did great. But you're not supposed to ask multi-faceted questions, but I break the rules all the time, and I think you got them all. But did you say 20 years from the filing?
Yeah, 20 years from the filing date. So for something like software, that is quite a long time because most software becomes obsolete after some number. If software is still commercially valuable after 10 years, that's quite a long time. In the case of drugs, there are drugs that can be commercially valuable for 100 years, and drug manufacturers, think 20 years is too short. But that 20-year period does apply in the U.S. essentially across the board for all kinds of patents.
But how long does it typically take between the filing and the acceptance of said patent?
Very often 2 to 5 years. The patent office is quite slow. There are processes that you can use to speed that up. One way is just to pay a fee to the patent office, and they will put you at the head of the line. But there are the patent office actually has some programs now, like for green technology. If you have something that will reduce greenhouse gas emissions, there's a few technologically based accelerations like that. If you're over 65 as an inventor, you can get things sped up. So there's a bunch of ways to get the process sped up if you qualify.
Do you have any protection at all while it's being reviewed?
While it's being reviewed, the main protection that you have is that if someone else files a patent application on the same invention, you predate them because you filed before them. And if there's a conflict between the two patent applications, you will be able to continue pursuing patent protection and the other party won't. The filing date is what's going to govern that. And so getting a patent application on file early is really important. Even so, that is true even if your patent hasn't been granted yet. I'll say this because a lot of people aren't aware. It used to be for a long time, until just about 10 years ago, that in the US, if two people filed patent applications for the same mousetrap, and those applications came into conflict, it was the party who invented the mousetrap first that would win out. It wasn't based on who filed first, and that is no longer true. And I only say that because I'm amazed at how many people I run into who have been inventors or maybe owned businesses that dealt with patents who still think we're under the old what's called first to invent system. We're not. And people who think we're under first to invent think, oh, we've invented something in my company. We don't have to hurry to file a patent application because if someone else files before us, we'll just come out and prove that we invented before they filed. But you can't do that anymore because
when did that change?
2013.
Oh, wow. Okay.
And that was to bring us into accordance with the rest of the world, which was already in a first to file system. We have a few quirks to our first to file system in the US, but that's essentially how it works.
Let me just ask one last question on this. If somebody files, if you filed for a mousetrap, it's still being assessed. I create that mousetrap. I'm making, good money off that mousetrap. Takes you 5 years. You finally get it approved. Do I keep my money because you didn't get accepted until then, or what?
The timing is a little bit tricky to get into, but if I get the patent granted and you are selling something that falls within the scope of the patent and you didn't start doing that until after I filed, then yeah, you're infringing my patent. And I can either demand that you stop or demand that you pay me for it, unless you can prove that you were actually selling the mousetrap or had published something about it before my patent application filing.
So the key is to find somebody that's got a good patent, make some quick bucks, and then get out. Because then they'll say, well, stop. Okay, I'll stop. I already made my money. Thank you. You did your services.
Yeah. So, the filing date is really important, and it's important to if you're going to start selling a product, it's really helpful to at least consider filing for your own patent on that as some sort of protection. For example, if you start selling a product, you file it and you obtain a patent on it, and then someone else sues you for infringing their patent. In many cases, you can end up striking a deal with each other where you each license each other's patents from each other, and thereby you can avoid, having to pay damages or stop selling your product.
Makes sense. And speaking of the rest of the world, is a patent valid across countries?
For the most part, no. As a general rule, for example, a patent in the US is just enforceable against sales or in manufacturing in the US. And that's generally true around the world. There are some places, like in Europe, there's a European Patent Office where you can file a single patent application and get it examined and then get that patent granted in multiple European countries. But then it's still essentially enforceable in each country. So for the most part, if you want to get a patent that's enforceable in multiple countries, you have to get it granted in multiple countries, which can be quite a time-consuming and expensive process, which is why most companies really prioritize their resources and their budgets when it comes to filing in internationally or in more than one country.
So I could ask more on that, but I want to get into the AI here in a second. So you're the founder of Blueshift IP. Where do you spend most of your time? You already said it wasn't in litigation. So where are you spending your time?
Most of the time is working with tech companies that are innovating, that are creating new kinds of software. I'm working with them before they've launched a product or a new product line to identify what is patentable about it, what about it is going to give them a competitive advantage, and what is it that they want to be able to stop their competitors from putting into their products. And then we develop a strategy for filing patent applications for the inventions that will have the most bang for the buck. And I work with them to obtain patents in the US and in other countries around the world. Once patents are granted, I also work on monetizing patents, which means obtaining licenses for patents, sometimes litigating, but usually it's negotiating licenses with other companies where they pay for permission to use the patented technology.
Do you get in and enforce a patent if somebody is violating a patent for one of your clients?
Yeah, I will typically partner with a litigation firm. Patent litigation is particularly in the U.S., is a really large scale, resource intensive process. So when a client of mine sees that another company is infringing its patents, we'll typically hire a litigation firm, or the client will hire the litigation firm directly, and then we'll work together. I'll continue obtaining more patents for my client while they're in litigation, and that will happen simultaneously with the litigation. And I have several clients who are in that process right now.
Enterprise clients, startups, or both?
Both.
Both.
Yeah.
How do they differ?
You know, I would say the big thing is the resources that are required. I mean, as I said, patent litigation is time consuming, resource intensive, and expensive. Typically for startups or small companies, it's not feasible for them to fund patent litigation. But fortunately, they actually have developed a variety of funding mechanisms for patent litigation. It's grown gradually over the past couple of decades, but within the last 5 to 10 years, is increasingly possible for small companies to get financing for patent litigation. As long as you can demonstrate that your patents are strong, valid, enforceable, and that there are other companies that are clearly infringing your patents, you have a good likelihood of getting funding for the patent litigation. And then that will enable you to pay for a litigation firm to represent you, which otherwise just would be out of the reach of an individual inventor or a small company.
Let me jump in then. Finally, I know in Inc. magazine, you had an article that you had written that was published. And I thought I would start here. I got so many different questions, but I'll start here. You had said, or the title at least was outlined as Patent Law Isn't Ready for AI. What do you mean by that? And has it changed since the time you wrote that article?
Yeah, I mean, this article is very, very recent. I think that, the article was intended to point out that, the law needs to catch up, and also that for companies who are innovating, we are in such a boom of innovation in AI now. The pace of innovation in AI is so rapid now, and there are so many fundamental and wide-reaching advances being made in AI nearly on a daily basis that this is a time. I think I used the term patent gold rush in there. This is a time when companies who are innovating in AI need to be filing patent applications on what they're doing, because there's only a limited period of time in which they can do that before their competitors do it. And whenever there's a field that either is completely new or that's undergoing an accelerated period of growth, like AI is undergoing now, that what tends to happen is there are some pretty broad-reaching patents filed in a short period of time, and then those patents can end up serving as the foundation for the whole field for many, many years to come. You may remember RSA, early encryption company. They had a small number of patents that covered the basic RSA encryption technique. Not a lot of companies were engaging in software patenting back then. I mean, this was a few decades ago. And by filing those types of patents early on, making them broad when it was still possible to file broad patents because the field was kind of wide open for them then. There hadn't been a lot of a competition with that technique. They got some patents. They made a business out of licensing the technology and the patents to competitors and made a huge amount of profit off of that. You mentioned 20 years. I remember seeing news articles that when the original RSA patents expired 20 years later, RSA's competitors threw parties because they knew they didn't have to pay license fees to RSA anymore.
Mm-hmm.
And so I'm saying we are in the midst of something like that now with AI, where if you can obtain broad foundational, what we in the field call pioneer patents on fundamental advances in AI now, you could set up your company for success with a competitive advantage for the next 20 years. And if you don't, a competitor is going to do it, and you'll be at a serious disadvantage. And these windows of time during rapid innovation, tend to not last all that long before there's then enough innovation going on that the field gets crowded with a lot of innovating, and then it's not possible to get really broad patents anymore. You can only start to get incremental patents on small improvements then.
The acceleration and pace, we often overuse the word unprecedented, but I think it might be unprecedented, and it's chaotic right now. I tend to, when I'm giving pitches, etc., I tend to talk about good actors and bad actors, meaning there's lots of legislation on the way. The European Union is already all over it. They're well ahead of the rest of the world. The U.S. is detailed in AI Bill of Rights. I know there's 150 bills on AI in play right now. There's also a popular data set, by example, that's going to lead into my question. It's called C4. It was used by Google, not to pick on anybody, but it trained their encoder decoder T5 foundation model. And in it, there's something like registered trademarks 200 million times without customer protection. I know there's a lot of lawsuits on different authors of books and that have been sucked into these models and in answering questions, their book, without their agreement. I guess this is an open-ended question. I got many others, but where do you think this is going to land and go from here? Because it seems a little bit like the Wild West.
It does. And, my expertise is primarily on the patent side. We're now getting into what would be more of the copyright and trademark side of things. I'll just say in general, I agree there's going to have to be some resolution to this question of either what kind of permission are companies going to need to obtain from copyright and trademark owners to train based on their data, and what kind of compensation are those copyright and trademark holders going to need to be able to get. It's probably going to be some combination of the two. I think back without knowing how it's going to play out, just remember at the beginning of the web, or I'll say the public internet, because it really wasn't the beginning of the internet, with Napster, right? So it was somewhat similar in a way. Napster decided to shoot first and ask questions later, meaning they just said, we're going to put out this technology that enables widespread what they called file sharing and what copyright holders called rampant piracy, right? So you call it a different thing depending on what side you're on, but it was technology that enabled copyrighted works to technologically be copied, certainly. And, a lot of people were debating then, how is this going to play out? Is it going to be resolved through lawsuits, copyright infringement? And there was a lot of that. But I think in the end, it really was resolved in a way when Steve Jobs at Apple pulled together a bunch of licensing agreements with the major copyright holders and made a bunch of business deals that everyone was happy with. And in a sense, that's what made the shift in streaming. That's what enabled music streaming to move forward in a way that was satisfying commercially to all the copyright holders, and that satisfied the public demand for streaming. So it may, I don't know, it's very dangerous to make predictions, but it may very well be that there is a business or commercial solution that will come out of this amongst all of the major stakeholders, really, but with the threat of litigation and government action behind it. That'll be the big stick driving particularly the tech companies to play nice, essentially, and come and make a deal.
Since everybody's talking about Taylor Swift, wasn't it her that essentially told Apple, no, you're going to pay me for my material?
Yeah, I don't know. But again, that's just a good example of how very often it ends up being private actors, whether it be someone,
Right.
a super powerful individual like that, or companies who end up making deals with each other with the shadow of copyright, trademark infringement, and governmental action hanging over them that causes things to resolve. And it's not necessarily the result of some huge copyright infringement verdict. I mean, back again, in the early days of the internet, there was this company, mp3.com, I believe, that did lose like a $200 million copyright infringement suit. So they did make the wrong bet, and that may happen again now. Who knows? I suspect OpenAI is making the bet that they can grow faster than the damages that'll come after them. And who knows whether that's correct or not. I'm certainly not prescient enough to make that prediction, but I suspect
that's a good way to state it. They're making a bet that they will grow and create or advance their business at a rate and pace that's much greater than the liability that follows.
That's right. They want to build. I suspect, again, I'm not in on their meetings, that they're trying to build up a war chest that's big enough that's gonna dwarf any government fines or penalties or copyright infringement verdicts against them, and that in the meantime they will be negotiating deals and through a mix of all of these things, they're hoping they'll come out on top.
So I've read several of your articles. Boy, there's a lot out there for those that are listening that you should take a look at. And I'm going to ask you a few questions that were in the articles. Maybe you'll remember the answer. Maybe you won't. We'll see how it goes. How should large language models be regulated, in your view?
I think that let's just stick to the intellectual property side of things.
Yep.
I think there does need to be both legal and commercial mechanisms for ensuring that individuals and companies have the ability to exercise some degree of control over how and where and why their data is used to train large language models. And there needs to be some way to get compensation for that. I think that a lot of the focus now on whether the training of a large language model and results in generating output that infringes a copyright is a little bit of a red herring. Because, in a lot of cases, it probably doesn't. Let's say you're using an art generator like DALL-E or Midjourney or one of them.
That's one of my questions too.
I think probably 99% of the time, they're not generating an output that's going to literally infringe a copyright of a particular artist. But I don't think that means that there's no responsibility on the part of the company that trained that model to get some sort of permission or grant compensation to the intellectual property holders whose intellectual property was used to train the model. Again, I don't know exactly how that's going to pan out, but that's what I'd like to see happen, is something where everyone is being treated fairly in this situation. I certainly think that artists who've spent their whole lives developing their craft and creating art and putting it up for sale and maybe putting some of it up for free in an environment in which large language models didn't exist, didn't know that this was going to be happening. They are, I hate to use the word entitled, but I think it would be fair, and any law school professor of mine would slap my wrist for using the word fair because it's not a legal term. But I think we should all want to see individual creators and companies that own intellectual property be treated fairly in this process, so that it's not just tech companies that train large language models reaping all of the benefits on the backs of everybody else.
Hey, I learned from Tom Cruise that it doesn't matter what's fair, it's what you can prove.
Yeah.
Podcast listeners, Al Martin here. As you know, I'm chatting with Robert Plotkin here. He's the author of The Genie in the Machine and also a founding partner at Blueshift IP. I had to break this in half. I don't often like to do it, but when they go long and I'm really learning a lot, then I want to break it in two. And I'm going to do that here. When we come back, we're going to talk about how to patent an algorithm, the method that Robert uses with patentability, future of AI from what he can see in those patents, and by example, the biggest misconception with IP law. So enjoy, please come back. I think you'll find it beneficial. Thank you. Bye.